A wonderful day to all of us out there. I am Chief Robinson Ario. I'm a legal practitioner and public affairs analyst. I'm compelled to make this video because of the attempt by a lot of people out there to misinform the public. And it's unfortunate that some pressmen are involved in this attempt. Now, the subject matter is the suit filed by Oyowoli against His Majesty. Now, it is imperative for us to point out that that is the second of that kind of suit. Now, we all will recall that before now, Oyowoli had filed a suit before, and he had progressed with the suit until trial. Now, what happened was that Oyowoli filed, and he filed as the claimant. He put two willing defendants. A willing defendant is a defendant who is working hand in hand with the claimant. And these willing defendants are Ayiri and Akoma. Now, when the other parties filed their defenses, Ayiri and Akoma filed what they call defenses, which agreed completely with the position of the claimant. Of course, your guess is as good as mine. The reason why that happened. Now, after pleadings had been fully exchanged, what I mean by pleadings being fully exchanged is that the claimant served his writ of summons and statement of claim on all the defendants. The defendant responded. They defended the action by their pleadings. And the claimant would file a reply to their defense. And then we come to the final stage that dovetails into trial, which is called the PTC stage. By the way, PTC is pre-trial conference. This is the conference that is designed to lay out the administrative procedure, to lay out the framework for the management of the trial per se. Now, at the level of PTC, it is that pleadings have been fully exchanged. In other words, everything that you intend to say, because under this dispensation, you front load everything you intend to say and every document you intend to tender. So the PTC will identify all the exhibits, identify the issues, narrow down the issues of facts. And all these were done. And the next stage was for Oyowoli to now enter the witness box and testify. Now, a date for that was taken. On that day, surprisingly, Oyowoli filed a notice of discontinuance, and the matter was discontinued. Now, that probably is the reason why you have not heard of this case before now. After 9 months, Oyowoli now came up again with the same case. Now, having done that, one of the first things we did that is provided for in the law is to raise the issue that Oyowoli has already seen all our defenses before now. And the law does not allow him to come back again because pleadings were fully exchanged during his first suit. And therefore, he cannot have a second bite at the cherry when the other person has not beaten the cherry. And so, the event of the last court sitting in Asaba was such that Ayiri and Akoma paid for and invited different pressmen to come to the court, and they granted interviews. In one of the interviews, I spoke for about 10 minutes. And I am surprised that 10 minutes, that particular clip was edited in such a way that the critical things I said in trying to explain this to the public were edited out. And so we must understand this. What was the case of Oyowoli during the first suit? It was exactly the same with this. And what the Supreme Court has said in the plethora of authorities is that you are free to file an action. If you file the action before the defendant files his response or before pleadings are fully exchanged, if you withdraw, if you decide to discontinue, then you can come back. But once the case has gotten to a point where pleadings have been fully exchanged and PTC concluded and a trial date fixed, the law will not allow you to come back. Why? Because it would have meant that you have seen all the secrets, you have seen all the arsenal of the defendant, and your coming back will enable you to refile. No court of law is going to allow you to do that. If the court below does and you are dissatisfied with it, you go upstairs. So the point we're trying to make is that Ayiri and Akuma are ganging up as defendants working in sync with the claimants to ensure that they paint the picture that the other defendants are afraid to do the case. Why would anybody believe that? You should ask them, when Oyowoli first came during the first suit, which is a different suit number from this, did all the defendants not file their defenses? Yes, they did. Were issues not fully joined? Yes, issues were fully joined. Was it not on the appointed day when Oyowoli was supposed to enter the witness box that he decided to discontinue? Yes, it was. And at such a stage, it accords with common sense that you should not allow such a person to have a second bite. I'll give an example. One of the issues raised in the defense of the first case was that Oyowoli never served pre-action notice, which is a precondition for his action to stand. Now, after withdrawing, he now took time to serve that pre-action notice. It's like examination malpractice. You go see the question for the exam and now purport to now want to sit the exam. So I am disappointed in those pressmen who came to the court and edited comments that were made, doctored them so one-sidedly, and never allowed the public to have the privilege of exactly what happened. I am making this video because of questions that have been asked. The case is that Oyowoli filed case A, and after all pleadings were filed, he discontinued it. He ended it. About 9 months later, he now filed, having studied all the defenses. And that's what the Supreme Court is saying. The Supreme Court is saying that it is overreaching. It means that you are playing hide and seek. You came to hunt for all the facts that the defendant could have used to defend himself. And when you now have the opportunity of firing back, you will put the defendant in a helpless situation. And so, please, please, and please, what has happened in court, even the preliminary objection has not been heard. It is the format. Whether the preliminary objection should be heard at the beginning of the case or should be heard at the end of the case. In other words, even the court itself agrees. All parties agree that the preliminary objection should be heard. But when should it be heard? That is what was argued, and it has been adjourned to 27th of March. So let's stop giving false hope. Let's stop building mountains where there are molehills. I am particularly disappointed at the pressmen who came. Even where you are paid, you should also ensure that there is a balancing. I saw my 10 minutes video edited in such a way that the most critical points were removed from them. I have asked the pressmen, please, can I have the full video? Up till now, they have refused to give to me. And this is the reason why some of us will hardly grant interviews. Thank you for listening.